Good afternoon, sir. Welcome you all. Over to you, Swastha. Sir, with your permission, shall we proceed? Mishra, sir, shall we proceed?
सुरेश मिश्रा
Yeah,
जी
yeah.
शुरू कर सकते हैं?
Yes.
बिल्कुल सर, बिल्कुल.
Yes.
Okay, go ahead.
Swastha, please go.
A very good afternoon to one and all present here. I, Swastha Kankaria, student of BLLB 5th year, welcome you all on behalf of MLNGE Societies, Manikchand Phade Law College, Chhatrapati Sambhajinagar, organized by the NSS on occasion of World Consumer Rights Day, that is, Consumer Protection Act 2019, a game changer. Without any further delay, I would like to call Ms. Kartiki Karad to introduce our today's resource person, Professor Suresh Mishra Sir, Chair Professor, Consumer Affairs, Coordinator, Center for Consumer Studies, Indian Institute of Public Administration, New Delhi. Over to you, Kartiki.
Thank you, Swastha. I, Kartiki Dattatreya Karad, student of BLLB 2nd year, take an honor to introduce today's esteemed chief guest, Professor Suresh Mishra Sir. Professor Mishra Sir, an expert on consumer issues, is currently the Chair Professor, Consumer Affairs and Coordinator, Center of Consumer Studies, IIPA. Sir hold a bachelor's degree from University of Mysore, Masters in Political Science from Jawaharlal Nehru University, New Delhi, Masters in Human Resource Management from Pondicherry Central University, DPhil from Allahabad Central University, and postgraduate diploma in journalism and mass communication from Calcutta. Before joining IIPA in 2007, Professor Mishra Sir was a professor of public administration and entrepreneurship development at Haryana Institute of Public Administration, Gurgaon. Sir has an advanced training governance at AOTS Tokyo, Japan, in total quality management at UK Civil Service College, Sunningdale, UK, in public policy management at Development Study Center, Rehovot, Israel. He participated in public administration program for senior officers of ENA, Paris, France, and also attended advanced training of trainers program on training techniques and methodology at Thames Valley University, Slough, UK. Apart from these, he has attended a number of training programs in India. I extended my sincere gratitude for providing me with an opportunity to introduce our distinguished guest whose presence graces us today. Over to you, Swastha.
Introduce us about the lecture.
Swastha. Good afternoon to all. Respected resource person, Honorable Shri Suresh Mishra Sir, Chair Professor of Consumer Affairs. President of the program, Honorable Dr. C.M. Rao Sir, Principal of MP Law College, all teachers and dear students. I welcome you all in this special webinar on the occasion of World Consumer Rights Day. Every year, 15th March is celebrated as World Consumer Rights Day. The consumer movement marks 15th March as a consumer rights day every year as a means of raising global awareness about consumer rights and needs. Celebrating today is a chance to demand that the rights of all consumers are respected and protected, and to protest against market abuses and social injustices which undermine those rights. World Consumer Rights Day is globally recognized with support from United Nations. On 15th March 1962, John F. Kennedy, President of America, addressed the first time of rights of consumer, and from 15th March 1983, he started celebrating and observing the 15th March as a Consumer Rights Day. Once again, we organize this Consumer Rights Day webinar in order to mobilize, in order to make awareness among the students about the new act and about their rights. Once again, I welcome you all in this webinar. Thank you. Over to you.
Thank you, sir. The goal is to normalize the trade relations based on sound, science, and consumer protection. With this, I would now like to request our today's resource person, Professor Suresh Mishra Sir, Chair Professor, Consumer Affairs, Coordinator Center for Consumer Studies, Indian Institute of Public Administration, New Delhi, to enlighten us with his knowledge and words on Consumer Protection Act 2019, a game changer. Over to you, sir.
Good evening. Can you hear me?
Yes, sir.
Yes, sir.
Okay, sir.
Go right ahead.
Thank you. Thank you, sir, for inviting me for this webinar and asking me to make a presentation on the Consumer Protection Act 2019. I thank Professor Rao and all of you for inviting me. Good evening, ladies and gentlemen. It's my pleasure to be here. And I'll be talking about the 2019 Consumer Protection Act and how it has filled the gaps that were left unattended by the 1986 Act. There are a lot of new features which have come, which will really favor the consumers to a large extent. I'll just share my PPT and then I'll start my presentation. It'll take 2 minutes. Is it visible?
Yes, sir.
Yes, sir.
Okay. Yeah.
इससे नहीं इससे
अनम्यूट करने के बाद नहीं चलता।
नहीं चल रही चल रही है। अब आप इसी से चलाएंगे, ठीक।
So I'll begin my presentation. The slides are visible?
Yes, sir.
Yes,
Okay,
sir.
sir. Now, talking about consumer protection in India, as you all know that we had a large number of laws before the independence also. It's not that consumer protection came only with 1986 Act, but there were other laws which were like Indian Penal Code, Sale of Goods Act, Drug and Cosmetics Act, Agriculture Produce Marketing Grading Act, and many more were there, which took care of the consumer.
आप चला देंगे, उसे मत हाथ लगेंगे।
Okay, but none of these laws enshrine rights of consumers, not provided a swift remedy to their complaints. So in a way, these laws were more punitive in nature. Even if a consumer went to the court and filed a complaint, he would in return get nothing much. Therefore, in 1986, the Consumer Protection Act was enacted and it for better protection of the consumers. Now, if you look at the 1986 Act, certain features were unique to it which were not there in consumer protection before the enactment of the 1986 Act. The very object of the Act was that it aimed at better protection of the consumer. It gave 6 rights, specific rights. For the first time, the consumers were given 6 rights. Exclusive forums for consumer disputes, a 3-tier redressal mechanism at the district, state, and the national capital, principle of natural justice and summary procedure for disposal of complaints, a lot of technical procedures were to be avoided, and it was a very simple process in which a consumer would go and based on certain papers, his complaint would be decided based on natural justice. It was speedy and inexpensive disposal of complaints, as the complaints were to be disposed of within 90 days. If there was the product testing, it took 150 days. So in 3 months and 5 months, the law says that the complaints must be disposed of. Consumer protection councils were set up at the national, state, and district level. These councils were in a way parallel institutions which talked about the policy matters of consumer welfare at each level, and they would move. The Act covered private, public, and cooperative sectors. So these are some of the very important features of the Consumer Protection Act of 1986. Now, over a period, the Consumer Protection Act was not able to achieve the objectives for which it was essentially set up in 1986. And by the time the 2-3 decades of its working, a lot of review was done, and the Act was not able to achieve its objectives because of various reasons. Delay in disposal of complaints was one of the major reasons. The n number of adjournments were given. The complaints were not filed in time. They were never disposed of within the given time framework. Therefore, the consumers were losing interest in the consumer protection mechanism that was there. It was no more expensive because it took a lot of time. Even though the Act says that the consumer need not hire the services of an advocate, but most of them went through an advocate, and therefore, with the advocates coming into the consumer protection redressal mechanism, it became expensive affair, time-taking, and a lot of technical issues and procedures were adopted by them. Too many technical procedures, just like the process in the civil court, filing affidavits, then again affidavits, there's no end to it, and it became so technical that the consumers started losing interest and the delay was there. Other problem was that lack of inadequate infrastructure. Many of the commissions are for the basic building. The required offices, some of the lack of qualified manpower. The Act, it was such that it in every fora at the district level, the district forum came from a non-legal background, therefore not aware of laws and procedures that are adopted in disposing of some complaints. So they did not know much, so everything rested on the district retired judge, who was the president of the forum, and therefore, in his absence, the other members were not able to dispose of the complaints because they did not have the adequate knowledge and skill to do so. Compensation that was awarded was very small. Therefore, it took such long time that the consumers spent more than what they really got back as compensation. The other important issue was that it started functioning like a civil code. All procedures they adopted of a civil code, because the district judges were, the district presidents were retired judges, district judges, so they, and then a lot of advocates came into the mechanism, and therefore they started following all the procedures of a civil code because that suited them all. Therefore, in the process, because of these problems, the consumers lacked confidence in the redressal mechanism, and very little complaints were being filed in spite of the commissions being in every district. The situation became so grave that the Supreme Court appointed a committee chaired by Mr. Justice Ajit Parasat, former judge of the Supreme Court, to look into the problems of why this Consumer Protection Act and the redressal mechanism has failed to this extent. Now, what is surprising, you'll find that IIPA also conducted a similar study before this committee went into, and the observations or findings of the committee, the report of IIPA, and the findings of the committee constituted Supreme Court are almost similar in a large number of ways. Now, based on the interim report that was given to the Supreme Court observed that the facts which have been emerged from the interim report submitted by the committee constitute a sobering reflection of how far removed reality lies from the goals and objectives which Parliament had in view while enacting the Consumer Protection Act 86. In a way, the Supreme Court said that everything has failed as far as the Consumer Protection Act of 1986 is there. Now, the Supreme Court further observed that the fora constituted under the enactment do not function as effectively as expected due to poor organizational setup, grossly inadequate infrastructure, absence of adequate and trained manpower, and lack of qualified manpower members in the executive body. Now, some of the forums, they function only for 2-3 hours in a day. And many of the positions of the members and president of the fora and commissions, they were vacant for a large number of days. Inadequate manpower was there. So these bodies were really not functional, and organizationally, they did not have the required capacity where they could handle these issues in terms of office space, in terms of infrastructure, and other things. Therefore, the committee found that this Consumer Protection Act has lost its sheen, and therefore there is a need to do something better and enable that things are taken to another level. In the meantime, in 2016, the UN guidelines on consumer protection came, and it talked about emphasis on e-commerce, data security and privacy, protection of consumers in financial services, sustainable consumption. These were some of the, therefore the overall environment was such that globally things had changed a lot. And as far as working of the Consumer Protection Act is concerned, the whole act had gone in almost non-implemented, and it was not serving the purpose for which it was made. Therefore, there was a need for a new act to protect the consumers. Therefore, the Consumer Protection Act 86 was not able to provide a comprehensive protection to the consumers due to a variety of reasons, which I have dealt in the earlier slide. You remember that in 1986, globalization and ICTC was not there. This process started only of the 1990s. Therefore, globalization and ICT changed the business environment, and therefore consumers were vulnerable to new challenges. You had the e-commerce that emerged as a major market platform, and with e-commerce coming, there was a different kind of problems that the consumers were facing. Lack of a regulator was felt as suo motu action could not be taken. In most of the sectors, you find that there is a regulator to take care of the interests of the consumers. But as far as Consumer Protection Act was concerned, there was no way the suo motu action could be taken except by the departments, which were really not able to do that. Promoting quality standards and innovation was one of the major drawbacks. The Consumer Protection Act of 86 did not have any aspects or any features that could help promote the quality and standards and bring about innovation. The consumer and market have also changed in these 3 decades. Therefore, there were a lot of new developments that had taken place, and there was a need for a new act where the process started sometimes in, say, 2016-2017. By 2019, we had the Consumer Protection Act. Just before the COVID, the act was framed and it received the assent of the President of India and was published in the Gazette on 9th August 2019. The new act came into force partially in July 20 and rest of the provisions in July 24, 2020. For operations, the act, the government has also notified rules on e-commerce, mediation, appointment of president and members of state and district commissions, general rules, National Consumer Dispute Redressal Commission regulations. All these have also been notified. If you look at the structure of the new act, you have the chapter 1, which talks about the basic definition and other preliminary. Chapter 2 talks about the Consumer Protection Councils. 3 talks about the Central Consumer Protection Authority, which is the new feature. 4 talks about the dispute redressal mechanism. 5th talks about deals with the mediation, which is also a new provision. 6th, product liability. It's a new provision. 7th, you have offenses and penalties, and then you have the 8th. So essentially, it has 8 chapters. Now, if you look at the highlights of the 2019 Act, it widens the ambit of the very definition of consumer protection or consumer that you equip the machinery to meet the new emerging challenges. Efficiency, bring in efficiency in grievance redressal. If you remember the 86, one of the major drawbacks was that the time taken was so long in disposal of complaints that the consumer's interest was really not being met. Broader definition of consumer, which now includes both offline and online transactions, inclusion of e-commerce, flexibility place of filing the complaint, increase in pecuniary jurisdiction, establishment of Central Consumer Protection Authority, mediation as a means to resolve consumer grievance, and product liability. Now, many of these, like the inclusion of e-commerce, filing of complaint at the place of residence, establishment of Central Consumer Protection Authority, mediation, product liability, these were all not part of the 1986 Act. So these were all new provisions which came in 2019 Act. The 2019 Act, essentially, the definition of consumer became broader because it includes both offline and online transactions through electronic means or by teleshopping or direct selling or multi-level marketing. This was needed because in 86, you did not have e-commerce, you did not have online, you did not have information and communication technology. So everything was only bought from a brick or mortar shop. And therefore, the definition had to bring in the electronic and other teleshopping, which is much prevalent now. The unfair contract has also been defined. Unlike the earlier 86 Act, it was never, what is unfair contract? It never defined. Complaint can be made before the State Commission or the National Commission in case of unfair contract. You will see that a lot of things, especially when it comes to real estate, then insurance, a lot of unfair contracts were there. Therefore, the 86 Act did not talk about unfair contract. Definition of UTP was broadened. Unfair trade practice, now not issuing bill or cash memo or receipt for the goods sold or services rendered is unfair trade practice. Refusing to take back defective goods or refund the consideration within a period of 30 days is also unfair trade practice. Disclosing to other person any personal information given in confidence is also unfair trade practice. So a lot of things which were not part of the 86 Act have brought in here because, you know, even today, many of the shopkeepers still are hesitant to issue the bill. So that has been now brought in under the category of unfair trade practice. Inclusion of e-commerce is important because e-commerce has grown into a huge marketing platform now, and the Act defines what exactly is e-commerce and its various provisions, and it notified the rules to regulate e-commerce and every e-commerce entity to provide information relating to return, refund, exchange, warranty, and guarantee. And all these are to be put up on their website for the benefit of the consumer. So e-commerce platforms are treated just like any other shop. So all these have delivery and shipment modes of payment, grievance redressal mechanism, payment method, security of payment, chargeback options, etc. have to also be very clearly put up, including country of origin. During the COVID, when the China standoff took place, the government of India banned a lot of products coming from China, but they were all coming through e-commerce platform. Therefore, government said that you have to also put up the country of origin of the product. So that is also there. Now, these are the 6 rights which are also there under 2019 Act. The 5 rights of 1986 Act: right to safety, right to be informed, right to choose, right to be heard, right to seek redressal, have been continued. The only difference is in the 6th right. It was earlier right to consumer education. Now under the 2019 Act, it has become right to consumer awareness. Now, there are questions: who can make a complaint? You see that except for the one addition that has been done, even earlier a consumer could complain, a registered voluntary consumer association could make a complaint, the central or the state government could complain, one or more consumers having the same interest, that is class interest, death of a consumer, his legal heir could do it, and in case of minor, the parents could do it. The only addition is the Central Consumer Protection Authority now has also been vested with the power to file a complaint. The procedures have been made simple now so that it's easier for the consumer to file a complaint and get justice. So the district forum is named now as District Commission. So you have District Commission, State Commission, and the National Commission. Earlier it was District Forum, State Commission, and National Commission. So now the nomenclature has been made same. Now a complaint can be filed where the complaint resides or personally works for gain. Earlier, the complaint could be filed only from the place where the cause of action has taken place. Suppose somebody coming from Kerala buys something in Delhi and goes back, and if he finds that there is some defect, he has to come back to Delhi and file the complaint. But now the consumer can file the complaint from where he resides or where he is working for gain. So that's the change that has taken place. Now, earlier people would not file complaint because who would come all the way from Kerala to file complaint here and then come and here. Now you can file a complaint at place of your residence, which has made simple. You can sit at home and file complaints. Earlier, when a complaint was filed, it would take 3-4 months for it to be admitted. Now the law says that within 21 days, if the complaint is not admitted, it will have deemed to be admitted. So it removes the period that was wasted. So now after 21 days, it's deemed that it has been admitted. Earlier it was not there. Opposite party needs to deposit 50% of the amount ordered by district commission before filing appeal before state commission. Earlier, the ceiling was of maximum rupees 25,000, which has been removed now. So it is 50% of the amount that it is there. Limitation period for filing of appeal to state commission is increased from 30 days to 45 days so that consumers have enough time, they can prepare and file. Second appeal to NCDRC only if there is a substantial question of law. suppose a complaint has been filed in the district commission. From district commission, it goes to the state commission. And from state commission, the second file is not there. So the final commission level itself. Or if a appeal is filed at the state commission, the final will be at the NCDRC. Only when the question of law is involved, second appeal will be entertained. So therefore, they have avoided the continuous litigation from one appeal to the other appeal to the other appeal, and by the time it goes to the Supreme Court, it will take a lot of time. Power of review has been given to the district commission, state commission, and NCDRC so that they can review their own orders. Administrative control, now the NCDRC has administrative control over the state commission. Earlier it was not there. Rules regarding appointment, conditions of service, etc. have been notified. Now, if you look at the provisions of Consumer Protection Act 86 and Consumer Protection Act 2019, you can see in the earlier act, you did not have a regulator. Now you have, in 2019, you have the Central Consumer Protection Authority, which is known as CCPA, to be a regulator. Complaint can be filed in a consumer court where the seller office is located. Now, from the place where he works, the provision for product liability has been brought in, where consumer can seek compensation for harm caused by a product or service. Pecuniary jurisdiction has been increased. In fact, it was earlier 1 crore, 10 crores, and more than 10 crore. But later on, in a report submitted to the Supreme Court, that is by IIPA, the pecuniary jurisdiction has been brought down. E-commerce rules are there, direct selling has been brought under it, and mediation cells are there. Now the consumer has to settle his complaint through mediation. Some of the new provisions that have come in. Now, this is Consumer Protection Council. They are basically set up at the national level, state level, and the district level, where they look at the policy matters for consumer welfare. Consumer Protection Authority is a new concept. It's a regulator of the interest of the consumers. It essentially regulates matters relating to violation of rights of consumers, unfair trade practice, false or misleading advertisements, which are prejudicial to the interest of public and consumers, to promote, protect, and enforce the rights of consumers as a class, and the Consumer Protection Authority, that is CCPA, consists of Chief Commissioner and such number of other commissioners as may be. The powers of and functions of the CCP are that CCP does not take any individual complaints. It will protect, promote, and enforce the rights of consumers as a class only. It will prevent unfair trade practices, ensure that no false or misleading advertisement is made. So if you look at the overall function and jurisdiction of CCPA, it will take up only complaints of a class of consumers, not individual consumers. Ensure that false or misleading advertisements are not made. And if you look at the functions of the authority, inquire or cause an inquiry or investigation, file complaints before the consumer commissions, intervene in any proceeding before the consumer commissions in respect of any allegation of violation, to and the factors inhibiting enjoyment of consumer rights, recommend adoption of international covenants and best international practices on consumer rights, undertake and promote research in the field of consumer rights, spread and promote awareness on consumer rights. So these are the broad functions of the Consumer Protection Authority, is also to ensure that not only the consumer rights of the consumers are protected, but also to ensure that a lot of international good practices are brought into the country as part of consumer protection regime. As there was no authority to take suo motu action, the Consumer Protection Authority, or CCPA, has been vested with the investigation wing. They can investigate the complaints when it comes to the health, and the investigation wing is headed by a Director General, and the district collector can also, on a complaint or a reference made to him by the central authority or the commissioner of a regional office, inquire into or investigate complaints within his jurisdiction and submit his report. They have the power of suo motu action. The central authority may, after receiving any information or complaint or directions from the central government or its own motion, conduct or cause to be conducted a preliminary inquiry. This was one of the major drawbacks which was not there earlier in consumer protection legislations. Now, complaints, as I said, that it can be done either way, in writing or in electronic mode. All district collectors have been empowered to take the consumer complaints. Commission or regional office can take complaint, or the central authority itself can take the complaint, but the complaints have to relate to class action. Power of the central authority given is they can recall of goods or withdrawal of services, reimbursement of the price of goods or service, discontinuation of practice, impose penalty, and an appeal to the National Commission within a period of 30 days can be made on any decision against the decision of the Central Authority. Penalties have also been provided for misleading advertisement. A penalty which may extend to rupees 10 lakh can be imposed on a manufacturer or an endorser. For every contravention, the authority may extend the penalty to rupees 50 lakh. Authority can prohibit any endorser from endorsement of any product for a period which may extend to 1 year. For subsequent intervention, it may extend up to 3 years. Endorser can also be, you have the manufacturer plus endorsers, all these film stars, sports persons, they are all the endorser of the product. They are also now liable for what they are doing. Then the mediation has also been brought into the 2019 Act. And when any matter comes to the district commission at the first hearing or any later stage, if it appears to the commission there exists an element of settlement, they can ask them to go for mediation. The district commission can, provided both the parties agree. And once it goes for a mediation, no appeal shall lie from any order passed under the district commission pursuant to settlement. Now it is the responsibility of the state government shall establish a consumer mediation cell attached to each commission or to the district or the state commission. The consumer mediation cell shall maintain a panel of mediators, and that also they have to be selected by a committee consisting of the president and a member of the commission. A list of cases handled by the cell, record of proceedings, and any other information as may be specified by regulations. The consumer protection mediation regulations have also been framed, and now matters not to be referred to mediation have also been enumerated. Proceedings in respect of medical negligence resulting in grievous injury or death, matters relating to default or offences for which compounding has been made by one or more parties, cases involving serious allegations of fraud, fabrication, forgery, cases relating to prosecution of criminal and non-compoundable offense, and cases which involve public interest. Now, these cannot be referred to mediation. Now, this is the structure of redressal mechanism under the new act. The pecuniary jurisdiction has been defined. For district commission, the 50 lakh is the pecuniary jurisdiction. State commission, above 50 lakh and up to 2.5 lakh. 2.5 crore. And for the national commission, it is about 2.5 crores. So this is the pecuniary jurisdiction, and finally it goes to the Supreme Court. Unfair trade practice, as I said, it has been already defined. The product liability has also been brought in, which is a new concept. These provisions will enable the complaint to claim compensation for the harm caused due to defective product and services. Now, product liability has been brought in as a mechanism to improve the quality and standards of the products that are being produced in the country. So therefore, it also acts as a deterrence more, because the companies now, since they'll be held liable, they have to prove that there is no defect in their product or service. Therefore, they would be much more conscious in trying to improve quality of products and services. So this is a good concept that has come, which was not there in India. They have also defined what a product is, which means any article or goods, substance or raw material, extended cycles. It defines what a product is. But it also says that it does not include human tissues, blood products and organs. Product liability means the responsibility of a product manufacturer or product seller of any product or service to compensate for any harm caused to a consumer. So this is important because now it will be assumed that because of the manufacturing defect, there has been some harm to the consumer. By such defective product manufactured or sold or by deficiency in services relating. Product liability action means a complaint filed by a person before a district commission or state commission or national commission for claiming compensation for the harm caused to him. Now, harm has also been defined. What exactly is harm in relation to a product liability? It includes damage to any property other than the product itself, personal injury, illness or death, mental agony or emotional distress. So they have defined what exactly is harm is. And any loss of consortium of services or other loss resulting from harm referred to the above, but shall not include any harm caused to a product itself or any damage to the property on account of breach of warranty conditions or any commercial or economic loss, including any direct, incidental or consequential loss relating thereto. Product liability shall apply to every claim for compensation under a product liability action by a complainant for any harm caused by a defective product manufactured by a product manufacturer or service by a product service provider or sold by a product seller. A product liability action may be brought by a complaint against a product manufacturer or a product service provider or a product seller. So it includes all of them, the whole cycle from manufacturing to the seller for any harm caused to him on account of a defective product. So this is a good provision that has been brought. The whole concept of product liability is there now. The liability of product manufacturer has also been defined. The product contains a manufacturing defect. The product is defective in design. There is a deviation from manufacturing specifications which are approved, and then the product does not conform to the express warranty, or the product fails to contain adequate instructions to prevent any harm or any warning regarding improper or incorrect usage. Now, a product manufacturer shall be liable in a product liability action even if he proves that he was not negligent or fraudulent in making the express warranty of a product. There are certain exceptions also given, provided to liability action has been initiated. Product liability action cannot be brought against the producer seller if at the time of harm the product was misused, altered or modified. So if anybody misuses the product or alters it, and then if something happens, it cannot be brought in. In any product liability action based on the failure to provide adequate warnings or instructions, the product manufacturer shall not be liable. If the product was purchased by an employer, the product manufacturer had provided warning or instructions to such employer. So if the instructions are not followed, then the exemptions are there. The product was sold as a component or material to be used in another product and necessary warning or instructions were given to the product manufacturer component. So these are some of the exemptions that have been given. It should also not happen that the consumer misuses the product or the consumer does not use the product as the instructions given. And then if he gets injury, then he goes and files a complaint. So also try to balance that the manufacturer or seller is not put in trouble or is not harassed by the consumer, even though the consumer any prescription drug which had not been prescribed by a medical practitioner, and if he is hurt, then the product liability clause will not be applicable. A product manufacturer shall not be liable for failure to instruct or warn about a danger which is obvious or commonly known to the user or consumer of such product. So there are certain products for which if you don't follow properly the instructions, you know that you'll be hurt or injured, and then the producer is not liable. So friends, these are some of the basic provisions of the Consumer Protection Act, which in short I tried to cover them. And this act is now in force. It is much different. You know, the mediation centers have been set up in most of the commissions. The online filing of complaints has started. The recent data shows that the disposal of complaint is much faster than the rate of filing of complaints is there. Earlier, the disposal was very slow, and therefore today, 2-3 things have happened. That the disposal rate is faster. It means justice being delivered is much quicker. Online filing is there, where the consumer can file complaint from his place of residence. He need not. The other is you have the provision for video conferencing. So you need not go to the commissions. You can be at home, and the through video conferencing, you can contest your complaint. Lot of power has been vested with the National Commission, which has supervisory power over the state commissions, which was not there earlier. So you have mediations now, you have product liability, you have the Central Consumer Protection Authority with more than 200 notices to various companies for violation of the Consumer Protection Act and the rights of the consumer. So therefore, you have a strong regulator now that is trying to regulate the market and ensure that unfair trade practice does not take place. So this is in brief what the Consumer Protection Act is, and there's a general consensus that it's a game changer and it has a lot of new provisions that the consumer protection regime to be more strong, and consumers can be much more safe under this act. So thank you. This is all from my side. Any questions, I'll be happy to answer.
Yeah, sir.
Yes, sir. From my side, it's over.
Yes. So just I have one question, sir. As this
Yeah.
act has newly introduced the referring the matters to the mediation, right?
Yeah.
So in this regard, we used to see these consumer forums as one of the alternative dispute resolutions.
Yeah.
So what do you think that by introducing this mediation, because the now act has also streamlines the timelines for the disposal of complaints. So what do you think that this introducing this provision for referring matters to the mediation will further delay the proceedings or not? As already these forums, they are not bound by the rigid rules of we used to see, and we also today also we see these are being one of the alternative dispute resolution system. So
Now,
what is your
what will happen, sir, on the first hearing itself? If both the parties agree, they can go for mediation. Mediation also has a time bound. It has just 2 months time is there. Within 2 months, if settlement takes place, you can come back to the commission and the commission will endorse the settlement that has taken place. So you have an option to get out the litigation now. Earlier, there was no option to get out of litigation. So now mediation, even the Supreme Court has been pushing for mediation. And the process of mediation is much simpler. And in the act, they have fixed a maximum 2 months for mediation is there. And if you cannot reach a settlement, then you go back for litigation. So we expect that large number of cases, at least the old ones which are pending for a number of years, they all will get cleared through mediation now, faster. New complaints that are coming, many people don't want litigation, but once they file a complaint under the 86 Act, they had no option but to go for litigation. And the complaints were never settled. In 3 months, the average time taken was nearly 3 years. So now people can opt for mediation and get out and finish off within 2 3 mediation. And the system that is being built up is gearing up for mediation. Any more questions?
Good evening, sir.
Good evening. Good.
I am Dr. Dipendra Pathak from Noida.
Yes, sir.
Sir, I feel that there is some lack in the new act. I would like to mention that some B2B site engage a consumer to consumer like Casify, OLX, Quicker. But this new act does not treat as a consumer. And we all know that Casify is involved with B2B and consumers. We sell or purchase from the Casify that use a second-hand product like mobile phone, any laptop. But if any complaint from Casify OLX, new consumer set doesn't say that you are treated as a consumer and you cannot file under this new act. Go to civil court. So, sir, I want to know your suggestion about these B2B companies.
No, but these companies sell old products.
They give a 6-month guarantee on the product. All they are treated like a direct selling. They have a store in every city.
Direct selling has a different rules.
Yes, sir.
Now the rules are being amended again.
Yes, sir. There is a need for some amendment in this new act, and also treated as a consumer who bought from Casify or OLX. There's some controlling guideline.
Yeah, but for different products, you can't have the same rules that apply. Now, something that is old is being sold off.
Yes, sir.
You can't treat it as a new product and treat them, both the consumers at par with each other.
Yes, sir. I know that not treated as a consumer, but sir, if I feel any problem from the company, and company has an office in a different countries and out India, so how can I file against them? There is one remedy available in civil code. We cannot file a claim under the act, sir.
Well, I really don't have much idea about it.
So, okay, sir. Okay, sir. Okay, thank you so much. A very informative session, sir.
Okay, okay.
Sir, there is a question in the chat box, sir. My question is whether new challenges like dark patterns and AI in e-commerce for it, is there any remedy in this Act of CPA 2019?
So now you are going to have new e-commerce rules. They are in the process. So you will sections they have stopped, not brought in out, but you are going to have new e-commerce rules which will cover all these things.
Okay.
They are already in the process of drafting new e-commerce rules.
Sir, another question, can this slide of exceptions can be showed again? Slide of exceptions.
Well, it's all there in the CP Act. I've only taken some of the broader major ones, but there are many more exemptions.
Okay.
Yeah.
Any other questions from any quarter? Okay, Rasta, go ahead.
Yes, sir. Yes, sir. Thank you, sir, for your guidance, insightful thoughts. Indeed, it was a very, very informative session for each one of us. You definitely made us aware about the gaps and the rights which are filled by the new Consumer Protection Act. Thank you, sir. We are honored to have you. Now I request our beloved principal, Dr. C.M. Rao, sir, to give the presidential address. Over to you, sir.
It gives me immense pleasure to talk a few words about this particular webinar. So we came across Professor Suresh Mishra ji in 2011. Apart from that, in several seminars, I met him personally. He's a committed person in the field of consumer affairs. So the critical analysis of the provisions, like a game changer of this particular thing, will definitely help to our students to understand what is past and what is present. In what way you are going to adopt the particular system into your professional conduct. This is the idea of the college, to have the person like Suresh Mishra ji for this seminar. And at the same time, I would like to draw your attention. There are all the laws. Anything you are talking about, laws will be there. But unless your mindset changes, your persuasion relating to the rights of the people are aware among the masses, the intention of the legislature, the implementation of the particular rules and regulations by the authorities is not fruitful. Hence, it is the law people who have to take care of these particular things and go to the masses. Consumer clubs, the students should also form a so area-wise consumer clubs in the areas where you are residing or studying, and basing on that particular consumer clubs, you have to brought this particular new criteria or new game changer to the knowledge of the people who are really need this particular thing. Once again, on behalf of the MLG Society, management, staff and students, once again, I congratulate Professor Mishra ji for giving me a wonderful opportunity to hear him after almost all 13 years. Thank you, sir, wonderfully.
Thank you so much, sir. Thank you. It was my pleasure to interact with you and your students. I once again thank you and thank the college management for inviting me. Thank you so much. Thank you.
Swastha, go ahead.
Thank you, sir. Now I request Dr. Pratibha Girbane, ma'am, NSS Program Officer, to propose the vote of thanks. Over to you, ma'am.
Thank you, Swastha. Good evening to all. President of today's function, Principal of our college, respected Dr. C.M. Rao sir. Resource person of today's special lecture, Professor Suresh Mishra, Chair Professor, Consumer Affairs and Coordinator of Center for Consumer Studies, IIPA New Delhi. My colleagues and dear students, today on the occasion of World Consumer Rights Day, NSS unit of Manikchand Pahade Law College has organized this special lecture on topic Consumer Protection Act 2019, a game changer. And being program officer of NSS unit, I am here to express gratitude to everyone who has contributed in conducting this event. At first, I express my gratitude to today's resource person, Professor Suresh Mishra sir, for accepting our invitation and giving his valuable time to us. Thank you, sir, for very detailed guidance on Consumer Protection Act 2019, as well as comparison in between Consumer Protection Act 1986 and 2019. I'm grateful to you on behalf of our college and staff and students. I'm grateful to our principal, Dr. C.M. Rao sir, for presiding over today's function and delivering presidential address, and also for his constant support in conducting such events. I'm thankful to Dr. Dinesh Kolte, NSS Program Officer, for giving introduction about the lecture. I express my gratitude to management members of Marathwada Legal and General Education Society for their continuous encouragement. I'm grateful to our Vice Principal, IQC Coordinator, all staff members for their cooperation in conduct of this event. I take this opportunity to thank NSS volunteers who conducted today's event, namely Swastha Kankaria for anchoring today's event and Kartiki Karad for introducing the resource person. I'm thankful to all the students who have participated very actively in today's special lecture and even have taken a part in interactive session. Thank you all. At last, I'm thankful to the organizers for giving me this opportunity to express gratitude. Thank you all. Thank you, Swastha.
Thank you so much. Thank you all.
Thank you, ma'am.
Yes. With permission of President, can we end the meeting now, sir? Principal, sir.